The Honorable the President.
Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth, and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President, petitions, papers.
Leader of Government Business.
Thank you very much, Madam President. Madam President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Public Utilities. The ministerial response of the Ministry of Public Utilities to the 11th report of the Joint Select Committee on Local Authorities, Service Commissions and Statutory Authorities, including the THA, 3rd Session 2017-2018, 11th Parliament on an inquiry into the efficiency and effectiveness of the Regulated Industries Commission, the RIC.
Minister in the Ministry of Finance.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the order paper and the supplemental order paper in the name of the Minister of Finance. The final report on the 10th actuarial valuation of the National Insurance System as at June 30, 2016. The reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Southwest Regional Health Authority for the years ended September 30, 2010 and September 30, 2011. The annual audited financial statements of the National Schools Dietary Services Limited for the financial year ended September 30, 2018. The report of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the Sarnwell-Laventille Regional Corporation for the year ended September 30, 2013. And the second reports of the Auditor General of the Republic of Trinidad and Tobago on the financial statements of the National Carnival Commission of Trinidad and Tobago for the years ended September 30, 2005, 2006, and 2007. Thank you, Madam President.
Leader of Government Business.
Thank you, Madam President. Madam President, I have the honor to lay on the table the following papers as listed on the supplemental order paper in the name of the Attorney General, the Minister of Public Administration, and the Minister of State in the Office of the Prime Minister. The Land Acquisition Requisition Order 2019, the ministerial response of the Ministry of Public Administration to the 15th report of the Public Administrations and Appropriations Committee, 4th Session 2017-2018, 11th Parliament on an examination into the expenditure and internal controls of the Ministry of Tourism, and the annual report of the Children's Authority of Trinidad and Tobago for the year period ending 2016-2017.
Reports from committees.
Senator Richards.
Thank you, Madam President. I have the honor to lay on the table the following report as listed on the order paper in my name. The 7th report of the Joint Select Committee on Social Services and Public Administration, 4th Session 2018-2019, 11th Parliament on an inquiry into the management of the Targeted Conditional Cash Transfer Program, TCCTP.
Senator Obika.
Madam President, I have the honor to lay on the table the following report as listed on the order paper in my name. The 23rd report of the Public Accounts Committee, 4th session, 2018-2019, 11th Parliament, on an examination of the audited financial statements of the National Agricultural Marketing and Development Corporation, NAMDEFCO, for the financial year 2008-2011.
Urgent questions?
Senator Mark.
Thank you, Madam President. To the Minister of Energy and Energy Industries. In light of reports that Paria fuel trading is to be sold, can the Minister indicate what impact this development will have on the supply of fuels to the motoring public?
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, it's obvious that Senator Mark didn't read the newspapers this morning. The three headlines are very clear and very explicit. Today's Express, government stops plan to dispose of Paria Fuel Company, no sale. Guardian, oops, not for sale. Newsday and the Guardian, Paria Fuel not for sale, says Can. Madam President, for the records, I want to read into the parliamentary records the actual press release that I sent out yesterday. And it's as follows. The Minister of Energy and Energy Industries, Senator the Honorable Franklin Can, has taken note of the newspaper reports that could give the impression that it is the intention of the government to sell the Paria Fuel Trading Company Limited. However, for the records, the Paria Fuel Trading Company Limited is a strategic asset, state asset, that plays a very important role in ensuring the supply and security of supply of liquid petroleum fuels for the transportation sector of Trinidad and Tobago and for the general public. The company is also invested with the ownership of strategic assets such as tank farms, port infrastructure, and real estate, which were previously owned by predecessor company Petrotrin. As Minister of Energy and Energy Industries, I wish to make it abundantly clear that the divestment of Paria Fuel Trading Company Limited is not within the current mandate given by the government to Trinidad Petroleum Holdings Limited. Accordingly, Trinidad Petroleum Holdings Limited has been directed to withdraw and retract any advertisement or request for proposal that may have been inadvertently issued for the sale of Paria Fuel Trading Company Limited. The public is assured that the government and the Ministry of Energy and Energy Industries will continue to maintain oversight of the restructuring of Petrotrin.
Senator Mark.
Yeah, just question two, ma'am.
Yes.
To the Honorable Attorney General, given the reports of imminent administrative changes at the magistracy, where more than 50% of the 452 employees do not have tenure, can the Attorney General indicate how many employees will be dismissed?
Attorney General, you have 2 minutes.
Thank you, Madam President. I can confirm that the information coming from the judiciary is that no one, I repeat, no one will be dismissed.
Senator Mark.
Was it?
Yes.
To the Attorney General, in light of the restructuring exercise being undertaken by the judiciary and its likely impact on hundreds of staff, has the representing union been consulted in the process?
Attorney General.
Thank you. I thank the Honourable Senator for the question. I take this opportunity to condemn, in the most straight of terms, the panic that is being put out by a politician who wears the hat as the president of the Public Services Association. There is, in the expansion of the criminal division, the creation of a number of posts, employment opportunities, and a betterment for the citizens of Trinidad and Tobago in the arena that is the criminal justice arena. I can tell you, consonant with the publication given on Friday by the judiciary, that the representative union has been fully engaged in this matter. There has been proper consultation, copious documents were provided, and it is a fact of law that permanent workers, which is whom the Public Services Association represents, cannot be dismissed. That is a fact of law that they must be put elsewhere into the public service if that were to be the case. Again, I am pleased to repeat, in answer to a sitting politician wearing the hat of PSA head, there are no dismissals, there's an expansion of the judiciary for the betterment of the people, and the PSA has been properly and fully consulted.
Senator Mark.
To the Minister of Health, having regard to the death of a pupil at a primary school in Maruga, reportedly due to meningitis, and the resulting fear at the school, can the minister indicate what steps are being taken to avoid an outbreak?
Minister of Health.
Thank you very much, Madam Speaker. Madam President, on behalf of the Honorable Prime Minister, the Cabinet, and the people of Trinidad and Tobago, I wish to express our deepest condolences to the families of two individuals, two young children, age 4, one was not in school yet, and one age 5, for the passing of these two precious lives. One can only imagine what their parents and families are going through, and we condole with them. The prevention of an epidemic is based around 4 pillars. 1, environmental management, which includes activities like sanitation, which has been done, public education for school, PTA, the general public surrounding the schools to look out for the signs and symptoms and when to seek medical attention. That has been done. Chemoprophylaxis, where you determine the most at-risk persons who were in contact with those two children to give them antibiotics to prevent them contracting meningitis, if that is the cause. That has been done. We have given chemoprophylaxis to 29 individuals. And the 4th pillar around which we stop an epidemic is vaccination. And this country has a robust program of vaccination, but there is no one vaccination to cover all 14 or 15 causes of meningitis. But we do, prior to children getting into school, administer 2 vaccinations, the HIV vaccination and the pneumococcal vaccine. And those will be given or have been given to all school children entering primary school. So that is how you prevent an epidemic. And I thank the Senator for the question. And we have done all of these things since we got the news that there were 2 suspected cases of meningitis. Thank you very much, Madam President.
Senator Mark.
Madam President, can the minister indicate whether the over 500 pupils who attend the Maruga Baptist School, primary school, could you indicate whether the Ministry of Health has taken steps to have those students vaccinated or at least interrogated to see to what extent they may have been infected or affected by this particular development?
Minister.
I thank the Honorable Senator for his follow-up question. As I said in the body of my answer, principals are supposed to check the vaccination cards of all students entering their schools. So the principals are our main gatekeepers. The students, before entering school, are to show proof via their vaccination cards when they got the vaccination, the HIV vaccination and the pneumococcal vaccine, were and signed off by the nurse that administers the vaccination. So it is the law before you get into school, similarly with vaccines like MMR and polio and so on. And may I add, Trinidad and Tobago has one of the best vaccine programs anywhere in the world and has always been so. Thank you again, Madam President.
Senator Mark.
Question to the Honorable Minister of National Security. In light of the recent murder of a witness to a double murder. Can the minister indicate what measures are being taken to protect other witnesses?
Minister of Agriculture, Land and Fisheries, you have about.
Madam President, I answer this question on behalf of the government. Madam President, I first want to caution Senator Mark that this is an ongoing police investigation. And there is
Honourable
nothing.
Senators, Minister, the time for urgent questions has expired, but I will allow the Minister to just complete his answer.
Thank you very much, Madam President. There is nothing so far to indicate that this particular murder was tied to anything relating to a witness to another criminal event. However, it's a very important question, Madam President. And I want to say that there is a justice protection program that is always available for witnesses who are willing to be part of that program. If a threat assessment is done and the witness qualifies and he or she is willing to enter the program, that witness can be facilitated. Madam President, this program has accommodated many witnesses in the past and has a success of 100% for witnesses who remain in the program. Madam President, on the other hand, many witnesses do not wish to place themselves in the program, and there are hundreds of state witnesses who are not in the program. And with these witnesses, if they have any concerns about their personal safety, it is important as a first step that they inform the police or any other relevant authority, and in that case, a threat assessment will be done. The Trinidad and Tobago Police Service and Intelligence Services will investigate any information or complaint relating to witness safety. I thank you very much.
Questions on notice, questions for oral answer.
Leader of Government Business.
Yeah, thank you, Madam President. Madam President, the government is pleased to announce it will be answering all questions, even except questions number 132, 167, and 169. For those three questions, we ask for a 2-week deferral. On written answers, we have supplied the answers to question 141 and 165. We ask for deferral of question number 164 for 2 weeks. Question number 188 is not due as yet.
So questions number 132, 167, 168, 169, and 164 are deferred for 2 weeks. Senator Mark.
Thank you, Madam President. Question number 80 to the Minister of Tourism.
Minister of Agriculture.
Madam President, I answer this question on behalf of the government, and I thank Senator Mark for this question, as largely relevant as it is. There have been several statements, Madam President, by the government that the state had incurred no project costs as a result of its discussions with Sandals. Since it is now well known that Sandals will not proceed with the project, no cost will be incurred by the government. Thank you.
Next question, Senator Mark.
Question number 81 to the Minister of Education.
Minister of Education.
Thank you very much, Madam President. The University of Trinidad and Tobago has advised that the professor was at that time on administrative leave and was not supposed to enter any premises of the University of Trinidad and Tobago without permission. Thank you.
Can the Minister indicate whether that matter has been now addressed? The administrative leave, has it now expired? And can he
Well,
goodly...
one minister, one question at a time. Minister.
Sorry.
Could you repeat the question, please?
I'm just asking whether this time the particular administrative leave that you made reference to has expired.
Minister.
Madam President, the administrative leave of the professor has been terminated with immediate effect, and the professor was required to proceed on vacation leave from the 1st of February 2019 until her retirement on August the 31st, 2019, as she had accumulated leave balance of 170 days. Thank you.
Next question, Senator Mark.
Question number 82 to the Minister of National Security.
Minister of Agriculture, Land and Fisheries.
Madam President, thank you very much. Madam President, while there's absolutely no basis for the issues raised by the South Florida Human Trafficking Task Force, I thank Senator Mark for the question. Madam President, the Commissioner of Police has indicated that there is speculation but little evidence to support the claim that many of the children and adults who have gone missing are cases of human trafficking. There have been no indicators identified by the anti-kidnapping unit to suggest that any of the missing children and adults are human trafficking cases. Furthermore, the majority of missing persons, children and adults, are either subsequently relocated or returned home. A small percentage of missing persons have not been located, and a small percentage of that small percentage are missing persons who are subject of homicide investigations. Madam President, the Department of State Trafficking in Persons TIP report of June 2017 upgraded Trinidad and Tobago's efforts in combating the trafficking of persons for sexual and labor exploitation, including women and children, to a Tier 2 ranking. So the ranking was upgraded, Madam President, in 2017. This tier upgrade in ranking was a move from the Tier 2 watch list. Madam President, Trinidad and Tobago has maintained this Tier 2 ranking in the June 2018 report, contrary to what the South Florida Human Trafficking Task Force has said. It is noteworthy that Trinidad and Tobago, contrary to what the South Florida Human Trafficking Task Force has said, was never ranked at Tier 3 in the U.S. DOS TIP report, and therefore the allegation is based on a very false premise. Tier 2 ranking, Madam President, means that significant steps have been taken to identify, protect, and prevent trafficking of persons and to prosecute the criminals involved in these offenses. I thank you.
Senator Mark.
Can the Honorable Minister indicate what efforts have been made to contact this South Florida Human Trafficking Task Force to address what he has described as misleading information?
Minister.
Madam President, the Counter-Trafficking Unit of the Ministry of National Security has not met nor interacted with members of the South Florida Human Trafficking Task Force. Neither can the CTU vouch for their credibility, background, and knowledge of human trafficking trends in Trinidad and Tobago. Members of the public and civil society organizations are strongly advised, senators also, to verify the credibility of persons and agencies who purport to be human trafficking experts. In particular, information on human trafficking in Trinidad and Tobago ought to be verified with an authorized local agency before making public proclamations. Madam President, if persons have information on suspected human trafficking activities, they can make an anonymous toll-free call to this Counter-Trafficking Unit hotline at 800-4-CTU. That, Madam President, is 800-4288. I thank you.
Next question, Senator Ryan.
Question number 127 to the Minister of Planning and Development.
Minister of Public Utilities.
Madam President, The government's efforts to promote recycling are led by the Trinidad and Tobago Solid Waste Management Company and revolves around the following 5 pillars: building capacity at that institution, public awareness, making recycling easy, developing the legislative framework, and developing a recycling industry. In the areas of public awareness and making recycling easy, SWIMCOL has adopted a multi-pronged approach in the education of citizens on the proper recycling practices. The company is currently engaged in the rolling out of a no pollution resolution campaign utilizing the print, electronic, and other appropriate media. As part of this initiative, the company has relaunched a successful Chase Charlie Away program, which would be taken to communities throughout Trinidad and Tobago. This is complemented by a public education initiative in primary schools with a focus on waste management, anti-littering, and recycling messages. For the previous year, SWIMCOL reached over 27,000 students through its primary school education program, and to date this year, they have reached over 17,000 students. In addition, Madam President, SWIMCOL has also been spearheading several programs to educate the citizens on sustainable workplace practices through the public sector recycling program and the workplace reduction recycling programs. These programs aim to educate employees, both in the private and public sector, on proper waste management practices and to include the desired behavior towards waste management, which will rebound to the wider society. Working in collaboration with the municipal corporations, SWIMCOL has also successfully piloted the curbside recycling projects in San Fernando, Point Forte, Cuva, Tabaqui, Talparo, and Arima. Discussions are far advanced for similar projects to be implemented in Saparia, Sarwa, Laventil, and Port of Spain. These projects are intended to promote recycling and at the household level. SWIMCOL message to the public are not just limited to waste recycling, but rather entails the promotion of the 3 R's: reduce, reuse, and recycle. These messages aim to encourage environmental conservation, minimization of non-recyclable waste, and the diversions of recyclable waste from the landfills. Thank you.
Senator Dinnerai.
Thank you, Madam President. Can the Honourable Minister indicate when the Bring Back Charlie program will be rolled out in the communities?
Minister.
Madam President, the Chase Away Charlie program is presently being rolled out, as I said, in the schools. They have reached 27,000 schools last year, and it's part of students, 27,000 students last year. And this year, we have actually touched 81 schools and 17,000 students. So this particular program is geared towards the school. There is the recycling program that we are geared towards the communities and dealing with the individuals, both in the workplace, through the workplace recycling program and the public sector recycling program, where we talked about, at that time, is not Chase Away Charlie, but it's a little bit more advanced because we're dealing with them at their workplace. And then also we have the community program, which is the curbside recycling program, which is being done with the municipal corporations. So we have that particular program is geared towards the schools, and it is already in place in the schools.
Senator Obika.
Thank you, Madam President. Question number 131 to the Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you, Madam President. The taxes collected from the Magdalena Grand Beach and Golf Resort for the period 2015 to 2018 totaled $21,425,787.35, broken down as follows. In 2015, $7,136,448.17. In 2016, $5,703,72.10. In 2017, $4 million, and this is all in TT dollars, $4,675,013.57. And in 2018, $3,911,253.50. And let me break these down further. With regard to the business levy and green fund, in 2015, the contribution was $168,202.26. In 2016, $433,574.33. And in 2017, $347,511.20. And in 2018, $297,862.60. Bringing the total to the business to the business levy and green fund of $1,247,150.39. Let me now go to the hotel accommodation tax, and this is broken down as follows. In 2015, $3,539,428.71. In 2016, $3,031,383.98. In 2017, $2,407,382.26. And in 2018, $101,154, bringing a total of $11,056,296.50. With regard to value-added tax for 2015, $1,878,916.67. With 2016, $711,902.19. For 2017, $463,452.38. For 2018, $155,332.56. A total of value-added tax of $3,209,603.79. With regard to NIS, which is a company expense, $1,549,900.53. For 2016, $1,526,211.60. For 2017, $1,456,666.73. So 2018, $1,379,956.80, making a total contribution of $5,912,736.67, giving an all-told contribution for 2015, as I had outlined earlier before. For the period 2015 to 2018, Magdalena Grand Beach and Hotel Resort has been operating at a loss, and therefore no dividends were paid. Senator Vieira.
Thank you, Madam President. I thank the Minister for the detailed response. I wish to ask if the Minister could give any indication as to why the taxes would have declined consistently over the period, from the 7 million to 3 million over the 4-year period. Just a general indication as to why, or if there's any specific indication.
Minister.
Let me give a general answer to say that Magdalena Grand has been operating at a net loss for a number of years. As a matter of fact, we have a net operating loss of 276 million TT dollars from the period 2008 to 2018. So that gives you a sense of the performance of the company, of the business.
Senator Hussain.
In light of, through you, Madam President, in light of the loss that the Magdalena Grand has been operating at and the burden on the taxpayers, is the government taking any steps or indication to remodel the business enterprise of the Magdalena?
Minister.
Yes, the government, Magdalena, which is owned by the VHL, by VHL Limited, has experienced financial difficulties from the onset. And I can go back to the overruns, which I can trace in terms of time and cost to complete the hotel. If I go back to the early days, with a construction cost with a variance of something like 77%. So whereas the initial building cost would have been about 170 million, this went up to 306 million and so on. And add to that the operational losses, which I just cited to you, 276 million. Yes, the government is making every effort to turn the prospects for the hotel around, and this is being done through ETEC. At the moment, we are in the final stages of finding a operator, an international operator under an international brand. And hopefully in the not too distant future, let's say within 3 months, hopefully there would be an international operator for the hotel. Concomitant with that would be, of course, renovations that would be associated with the demands of the consultant, and all of these would be determined during the next few months as we finalize the operator. Concomitant with that is a lot of work in terms of promoting Tobago, attending to matters of airlift, and all of the other kind of support will be necessary to promote the tourism destination.
Next question, Senator Ubika.
Thank you very much, Madam President. I understand 132 is to be first question number 133 to the Minister of Trade and Industry.
Minister of Trade and Industry.
Thank you, Madam President. Taxes collected from the Hilton Trinidad Conference Center for the period 2015-2018 totaled $81,131,777.78, broken down as follows. In 2015, $418,418,000, in 2016, $19,947,109.23. In 2017, $973,000, too many figures, Madam President, $826.58. And in 2018, $392,352.34, all in TT dollars. With regard to the Business Levy and Green Fund, for 2015, $154,075.55. With regard to for 2016, $412,989.62. For 2017, $391,862.93. For 2018, $308,123.77, with all told, with a total of towards the Business Levy and Green Fund of $1,269,051.87. With regard to corporation tax, in 2015, $1,033,086. In 2016, $2,600,047. In 2017, $1,014,000. In 2018, $780,000, with a total of $5,427,000 and $427,556. With regard to value-added tax, in 2015, $1,483,621. 2016, $523,930. 2017, $1,016,715. In 2018, $633,000 and $633,076. With it all told, $3,657,343. With regard to hotel accommodation tax, $9,717,579. In 2016, $8,619,304. In 2017, $387,015. Within 2018, $8,563,908. And all told, with regard to the hotel accommodation tax, $35,287,805. With regard to NIS, which is, again, the employer expense only I speak to here. With regard, in 2015, $3,390,004. In 2016, $3,297,877. In 2017, $3,121,850. In 2018, $3,539,508. All told, with regard to NIS, $13,351,239. With regard to pay as you earn, $6,040,123. With regard to 2016, $4,490,539. 2017, $4,042,384. 2018, $7,567,736. All told, pay as you earn, $22,140,783. The Hilton Trinidad and Conference Center operates under a lease agreement with ETEC, the Evolving Technologies and Enterprise Development Company Limited, and therefore the question of a dividend payment does not arise. Thank you.
Senator Vieira.
Thank you very much, Madam President. Given the profits of Trinidad Hilton being so significant, 35 million plus just at corporation tax alone, in terms of the contribution to the state, can the minister indicate if further engagement of this brand can be done or will be done for installations in Tobago?
No, that question does not arise. Next question.
Thank you very much, Madam President. Can the Honourable Minister indicate regarding a dividend, or given that the term dividend doesn't apply, but what contributions by way of a shareholder agreement is given to ETEC?
Minister.
Thank you, Madam President. But that's not a question that I can't give you an answer right now. Perhaps you would want to ask another question.
Next question, Senator Hussain.
Thank you very much, Madam President. Question number 168 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, the remuneration packages for the directors of Heritage Petroleum Company, Paria Fuel Trading Company, and Garakara Refining Company are based on the guidelines set out in the State Enterprises Performance Monitoring Manual under Group C. The package includes monthly fees and traveling allowances, which are as follows. For the chairman, $7,500 per month, deputy chairman, $5,550 per month, and a director, $3,700 per month.
Senator Hussain.
Madam President, through you, does these figures that the Minister indicated to this Honourable Senate include any other benefits or allowances given to these directors?
Minister.
As I said, it includes monthly fees and traveling allowances. There are no other benefits that come with the job. The job is basically public service.
Public business, government business, bills, second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Companies Act be now read a second time. Madam President, I am giving ample notice to all my learned colleagues that we are going to be quite busy in the next couple of weeks in considering urgent and important work in respect of which there has been a considerable amount of preparation, analysis, consultation, double check, and then reformulation. And I say that specifically in the context of our obligations to our international reporting assessors. Trinidad and Tobago finds itself, as we know, all of us now quite well, in the middle of a global movement where there is an attempt to wrestle with the scourge of crime as it manifests itself in money laundering, the financing of terrorism, corruption, a lack of transparency. And in this particular matrix, the United Nations Security Council resolutions have found themselves into the national laws of our country. That UNSCR resolutions, those many conventions that we have all signed on to and are quite aware of, be it the Vienna Convention, the Rome Conventions, whatever, Palermo Convention, whatever they may be, these conventions have now found themselves quite properly rooted into the national legislation, agenda, and operationality of the world as a whole. That is also to be found in multiple fora. I bring to your attention, Madam President, of course, the Financial Action Task Force, the OECD and their declarations, and the G20 declarations that manifest in the G20's version in the Global Forum pot. And if we take the Global Forum environment of some 190 countries and a similar number in the Financial Action Task Force, as that is operated from the central body, the FATF, and through something referred to as FSRBs, which are regional sub-bodies, FATF-styled regional bodies. There are 9 of them. The world has said, in treating with this scourge of criminality, that jurisdictions ought to lift themselves into a degree of compliance to ensure that there's transparency so that we can follow the money in relation to activities. This, very fortunately, coincides with this government's agenda, as is now well known to honorable senators and the national public. The mission in the first 2 years was a reformation of the criminal justice system. The mission involved getting the very many moving parts working so that laws can be operationalized. And on this particular cycle of 2 years, including this one and the last year just gone, those 2 years, as a country, we're focusing on the laws to treat with getting the trail of evidence as to where money resides in money laundering, financing of terrorism, corruption. It is for this purpose that there are 3 particular pieces of law that this Senate will be obliged to consider, and they are this bill, the Companies Amendment Bill. Secondly, the establishment of a non-profit organization regime where you are registering and regulating non-profit organizations as they exist in their thousands in our country, unregulated at present. And the third aspect that falls for consideration is the civil asset forfeiture, explain your wealth legislation. Trinidad and Tobago underwent its mutual evaluation, 4th round mutual evaluation, in the Financial Action Task Force subset of the Caribbean Financial Action Task Force. We had our on-site attendance and mutual evaluation in January 2015. Our predecessor government elected to put Trinidad and Tobago first in line for that assessment, even though we were not prepared for the assessment, and even though we had not completed our 3rd round assessment. They volunteered that our 3rd round and 4th round assessment should be rolled up in one, and quite frankly, we did not fare well on the assessment. That assessment brought us into failing grades on the recommendations that the FATF says that we ought to have managed and the immediate outcomes. Now, we know the FATF recommendations are 40 in number and the immediate outcomes are 11 in number. Trinidad and Tobago, not having fared well, we were put into what we call 2 forms of supervision. On the first hand, we were put into, because of the size of our economy, over $5 billion US, we were put into what is called the International Cooperation Review Group, ICRG, which is the body that supervises your commitment to achieving your workout of a bad situation, and that's over a 3-year period. And we were also put into something called enhanced follow-up in the CFATF regime. These 2 regimes, quite simply put, tell Trinidad and Tobago, give a high-level political commitment, publish only inside of FATF, not outside, an action plan, be judged by way of analysis from review experts in what they call joint face-to-face review, joint group face-to-face review. Let them attend upon you, check your progress, and be assessed 3 times per year in the FATF, and similarly in the CFATF. So there's a constant monitoring and evaluation process in the ICRG FATF and also in the CFATF. Trinidad and Tobago's mutual evaluation report was published on June 2016, and in June 2016, 3 years was given to this country to achieve its markers. We are down to the end right now. Our review in final form comes up in the May plenary in Orlando 2019. May 2019 is our final assessment, and we must report on a face-to-face basis by April 25th, 2019. The last 3 items to be reported on: this bill, which causes an amendment to the Companies Act, the non-profit organizations, which will be laid in Parliament this week, and the civil asset forfeiture and explain your wealth regime, which will be laid as soon as Cabinet has considered it this week, assuming that Cabinet, of course, approves it in the form that it is. So I'm putting members on notice that we have some work to do. Now, these laws, this amendment in particular, is intended to treat, as I said, money laundering, financing of terrorism, corruption. It's intended to treat with recommendation 24 and immediate outcome 5, recommendation 24 and IO 5. These essentially talk about transparency. And transparency from the government's perspective must be had in 3 places. 1, companies or entities that are corporate in nature. 2, land transactions. And 3, cash. And that's why we have engaged in so much work in the laws that we've brought to Parliament to treat with money laundering, mechanisms, etc. As it relates to companies and for persons who are not schooled in law, I'll put it as simply as I can. There is a distinction in law between legal ownership and beneficial ownership. Beneficial ownership is referred to as fair or equitable ownership. It is a type of ownership which prevails over legal ownership. It is to be found in the example where someone tells, for instance, me, Faris Al-Rawi, please buy a car. Go down to Toyota, give them the check, and tell them you came to pay for the car, and this is the registration number. I arrive at Toyota, I give them the check for the car, certified draft. They say, what's your name? I say, Faris Al-Rawi. They write it out. Next thing you know, the certified copy comes with my name, Faris Al-Rawi, on it, because I tendered the check. Who's the real owner? The person who gave the check and mistakenly finds himself as the legal owner on the certified document? Or is it the person who, in fairness and in equity, gave that money? It's his money by way of a loan or by way of savings. That person is constituted as the beneficial owner. And the rule of law is that equity prevails over law. So if there was a challenge as to who the real owner is, the beneficial owner, if he went to court or she went to court, can tell the court, this is the evidence by which I was the beneficial owner. I really paid for the car. Here is my check. Here is the certified copy. This is the circumstance. Faris Al-Rawi, in this example, is not the real owner, and therefore equity prevails. This bill, 11 clauses long, treats with amendments to the Companies Act in an interrelated and very logical fashion. The first fact is that in these 11 clauses, the first one is the short title. We all know that that's straightforward. The second one says the bill shall come into operation when you proclaim it. The third one says this act, what it means. It refers to the Companies Act, what the act means. Then we deal with sections 4, 5, 6, 7, 8, 9, 10, 11. Section 4 and section 8 and, clause 4, clause 8 and clause 11 all relate to the same thing. They relate to different sides of the equation for local companies and external companies and how we treat with something called bearer share warrants or share warrants. And I'll explain that in a moment. Basically, it's like a dollar bill. He who holds the dollar bill owns the dollar bill unless you can prove otherwise. It was stolen, etc., etc. You present a dollar bill and you pay for something, you transfer ownership of the dollar bill, a $100 bill. That's effectively a negotiable instrument which is owned by the bearer. And bearer share warrants or share warrants, in a very simple term, is that the person may own stock or shares in a company in the fashion of simply holding the certificate. So clauses 4, clauses 8, and clause 11 treat with that, and I'll come into the nitty-gritty in a while. 4 treats with the local side, 8 treats with external companies, and 11 amends the regulations that relate to both. Clauses 5, 6, and 7, clauses 5 and 7, 5 and 9 relate to how we deal with certain aspects of record keeping, the regularity of record keeping, making it more than just annually or before your first anniversary. And importantly, clause 9 treats with a concept called beneficial ownership, that you must declare who the real owner of a share in a company is. And I'll explain that in detail in a moment. Clause 10 treats with the official receiver. It's a lacuna in the law caused by way of a repeal of the Bankruptcy Act and the replacement of that act by the Bankruptcy and Insolvency Act, where there was an omission to state who should manage property that fell to the benefit of the state effectively. There was no real owner, and we put that in the official receiver. That's the simple purpose of this law. Madam President, what time do I end?
You end at 3 minutes to 3.
Thank you very much. Let's get to aim, proportionality, legitimate purpose of this legislation. Why do we need this? Why do we need to have a conversation about who the real owner of this is? Our Companies Act is pellucidly clear. You can go to the registry. You will see who the real owners of shares are as they relate to legal ownership by way of the filed documents called annual returns. Annual returns are filed for Form 27, Form 28, Form 29, and Form 23. External companies file annual returns. Non-profit companies file annual returns. And limited liability companies form annual returns. Now, there are different types of companies. You have companies that are limited by shares or guarantee. You have companies that are externally registered companies. You have companies that have no shares. You have companies that are effectively non-profit or not-for-profit entities. And of course, you have what we call former act companies, which existed under Chapter 31, Number 1, which is the old laws of Trinidad and Tobago. In this environment, we are now required to look at, is there a mischief in Trinidad and Tobago that this act seeks to treat to claim by way of amendment some remedy for? And the answer to that is, of course, yes. Let's go to the statistical information in our country. On the register, the public register of companies in Trinidad and Tobago, there are standing, as at March 8th, 2019, 104,168 registered companies. Of that, 86,190 are actually active. The rest of them, some 20% of the registry, is inactive. And you will see in today's newspaper a notice that the government is moving to strike off companies that are inactive, and I'll explain why in a moment. Total profit companies, we have profit non-public companies, there's 77,472. Profit public companies, there are 129. Total non-profit companies, 7,958. That does not include the non-profit entities that are not registered, which are in the thousands as well. And total external companies, 596, and then no category, 35. But it is the financial intelligence unit statistics that really jump out at me. Honorable Senators, in the period 2015 to 2018, the Financial Intelligence Unit, which is the entity which receives suspicious activity reports, SARs, and suspicious transaction reports, STRs, that FIU, which regulates financial institutions in terms of reporting aspects, and listed businesses pursuant to the first and second schedules of the Proceeds of Crime Act, which is lawyers, real estate agents, pawnbrokers, etc. The total figure for suspected activity, suspicious activity, for the period 2015 to 2018 inclusive is, in our little country, 14,931,486 $119,316. Let me repeat that. In our little Trinidad and Tobago, in a 3-year period, $14.9 billion of suspected activity and suspected transactions. But in that pack, 353 companies were found in that. 350 companies registered in Trinidad and Tobago were involved in that suspicious activity or suspicious transaction matrix. And it's important to note that the activities included, this is the suspicious activities, breach of exchange control, corruption, drug trafficking, financing of terrorism, fraud, human trafficking, money laundering, suspicious activity, tax evasion. And we have had in that aggregation of that 15-odd billion, we've had transactions that have been completed and transactions that have been stopped by way of the operation of the FIU. But in getting to these companies, how much use is it to just see a nominee person, a driver who you can't find, a made-up name who has a forged identity? How useful is it to have a legal owner who really isn't the beneficial owner or the real owner of shares, or worse yet, to have a defunct company with somebody left on the register simply because they couldn't afford to update the fines that are associated with late filings, and that's quite hefty, and therefore they leave the company in a defunct state, and then you do, like I gave the example in the House and I'll repeat it here, you take the juice cans that went to the United States of America, $1 billion worth of cocaine inside the juice cans, and you use a defunct company, not up to date in Trinidad and Tobago, and all the shipping documentation is in that company. So, do we have a problem in this country? Yes. Is it to the tune of billions of dollars? Yes. Do we know who the real owner of something is? No. And ladies and honorable senators, this prevails equally as it relates to land and cash. So today we're dealing with companies. I can tell you we're coming to deal with land and we're going to deal with cash. This bill, let's deal with the clauses of the bill. The clauses of the bill are really quite simple. If I look to, before anything else, the preliminary provisions in the legislation that we're seeking to amend, let's start off with Clause 4 as it relates to Clause 8 and Clause 11. If we look at Clause 4 of the legislation, we're looking at an amendment to Section 33. What we're saying in the amendment to Section 33 is we're saying 33 deals with share issue. That's the Companies Act. Now, the Companies Act is a robust piece of legislation. It's in need of some updating. I can tell you we're doing a general overhaul of the Companies Act now as a result of case law, as a result of movement. The fines and penalties are far too low. We're harmonizing that approach. But today we're dealing with beneficial ownership and we're dealing with share warrants and bearer share warrants. Section 33 of the Act, which we seek to amend by Clause 4 of the legislation, previously said no company may issue in subsection 2 bearer shares or bearer share certificates. It omitted bearer share warrants. And therefore we propose that we insert now bearer share warrants as a specie alongside share certificates, bearer share certificates, and we seek to take care of the three aspects in which that can be manipulated. Firstly, the issuance of those species. Secondly, the conversion into shares. Thirdly, the exchange of those shares. And then we, of course, provide a penalty that no company may issue those bearer share warrants or bearer share certificates. We then go on in that clause to provide a formula for rational association. Effectively, this clause requires the company to put out a notice calling for the holders of bearer share warrants or bearer share certificates to bring them in. There's a process and a time frame for that. Once brought in, they're converted into a register where it is known who the owners are. They're converted in that process. If the bearer share holders or share warrant and share certificate holders don't bring in the certificates, then they approach the court under the due process environment to move for a cancellation of those instruments. And of course, we put the corollary to that, or I should say the flip side to that. We provide for the utilization of the remedies provision in the Companies Law, Section 245, well known to practitioners who practice in this area, where you can apply to the court and say, listen, my share certificate was cancelled, I did not know about it. You approach the court and you have it restored, and then the register goes across with your name on it. So we provided the balanced, proportionate measure to the treatment of the cancellation, the calling in, the registration, the cancellation, and the restoration provisions that exist in the law. We have, of course, said that there is to be penalties provided along the way for failure to do certain things. And then we provide that annual returns must be provided and that there must be a register established for shares. And then we define what a bearer share warrant is in the last position. This is to be replicated in our consideration of Clause 8. In Clause 8, we are taking for externally registered companies. Remember, there are different types of companies. You can have a company which is homegrown. That is a company under the Companies Old Ordinance, which was continued under the Companies Act. You can have a freshly incorporated company under the Companies Act by filing your articles of incorporation, etc., the package of documents that go. And very importantly, you have another method where you can bring your company from abroad, from any jurisdiction in the world. You can have them notarized, translated, and then you come under the provisions of Part 5 of the Companies Act for external registration of companies, and then you transplant that corporate entity from its foreign jurisdiction into your local jurisdiction. And that, of course, has significant advantages to people who deal with it as it relates to taxation, as it relates to write-offs, as it relates to transfer pricing, tax avoidance, etc., carry forward losses. And that's obviously why many of our international oil and gas companies seek to register themselves as external companies under the Companies Register here. So that's a species in and of itself. Insofar as bearer share warrants and share certificates, bearer share certificates can exist in the external registration environment. Clearly in Clause 8, we've got to factor the same methodology that we did in Clause 4 to have the notice, the call-in, the registration, the cancellation, the restoration, and the limitation, but we can only limit within our territory because another jurisdiction may very well allow negotiable instruments of that type, bearer share, to exist. So we have only confined ourselves to our territoriality, not going extraterritorial, because those transplanted companies may very well allow it in their jurisdictions, though I doubt in today's world. If we go to Clause 6 and Clause 5, if we look at Clause 5 first, Clause 5 treats with the records of a company, and Clause 5 is treating with Section 177 of the Companies Act. The Companies Act allows for that provision record keeping. 177 says a company shall prepare and maintain at its registered office its records. Membership showing name, latest known as a statement of shares, the number of shares and the category and classes of shares is what we seek to add now. Because we did not have a statement of shares moving beyond that. We did not subcategorize what is really of interest to the world, which is what the shareholding has associated with it in terms of rights and privileges, limitations, if any, more than just the stated capital in the company. So we want to make sure that we know what that is in the event that there is something outside of the articles of incorporation or continuance that may provide for limitations that are not expressed. We then move in that same clause to say a company which issued share warrants, bearer share warrants prior to commencement shall prepare and maintain a register, and again we deal with the particulars of that. So we're making sure in the record section in Section 177 that we capture what we've done in Clause 4 and in Clause 8 as it relates to record keeping in a company. We then propose in Clause 6, where we're dealing with access. Sure?
Attorney General. Thank you for giving me. Just before you move on to the other point, Madam President, I just wanted to ask the Honourable Attorney General, having prescribed these mechanisms that are supposed to eliminate bearer share warrants, bearer shares, and we have bearer shares already, what do you foresee, if you can just address it before you finish, you don't have to do it now, how do you foresee that persons who continue to engage in this kind of activity will be caught within that net to be prosecuted under the provisions that we have prescribed for us?
The golden question, operationalization to make law make sense, as Senator Ramlin always brings sensible arguments to the floor. I hope to catch it in just a moment as soon as I finish these, okay? So access to records in this clause 6, 190, we're making sure that you capture the records which you're keeping, both for the beneficial ownership side in the new 3376, which we'll come to in clause 9, and also for the bearer share aspects that we had before in those points. I've already dealt with clause 7. In clause 7, we're treating with section 318 of the Companies Act. We're making sure that the number and category, in the same fashion that we treated with number and category in clause 5 for record keeping, that we harmonize that for local and for externally registered companies. I want to get to clause 9 because that's the big one. Clause 9 is where we treat with beneficial ownership. Now, the concept of beneficial ownership is quite well known in our jurisdiction. The securities legislation has it, the FIA has it, the financial obligations regulations has it, the Companies Act has it. The Companies Act actually has it in the definition section, section 4, where beneficial ownership includes ownership through a trustee, legal representative, agent, or other intermediary. But what we're seeking to do in a new part, and this is where we are adding in the crunch aspects for a new part 5A, we're adding in a whole part to the Companies Act to treat with beneficial ownership. We now propose in a new 337A through E inclusive, new sections, that we create this regime for the establishment of beneficial ownership, and we do it this way. The first thing that we do, which is material, is that we define beneficial owner. And beneficial owner, as it's set out in the bill, captures the natural person or ultimate owner. It captures the circumstance where you may not know who the natural owner or ultimate owner is, and therefore there's a legal assumption or designation of who that person is in the definition of beneficial ownership. We've taken this from the Commonwealth examples, from the laws of India, from the laws that we have traversed in coming to this exercise, and for the record, I can say that in our consultation and reflections, we looked at the laws of India, Jamaica, United Kingdom, Cayman Islands, and certainly Barbados. And in our consultation, we consulted with the TTSEC, Stock Exchange, the Bankers Association, Law Association, Registrar General, the FIU, the National Anti-Money Laundering Committee, Finance, Ministry of National Security, and of course the Attorney General, and we had public comments come in. But in treating with this expansive definition for beneficial owner, as we've put it here, we ultimately seek to capture who really is the de facto, meaning the person in fact that controls the arrangement behind these entities. And very critically, what this law does is to put in an obligation, which is a very important one, by way of a marker in the new subclause 8. And listen to what new subclause 8 provides for in this 337B. No right or interest in relation to any share in respect of which a declaration is required to be made under this section, but not made by a beneficial owner, shall be enforceable by him or by any person claiming through him. That is the nuclear bomb in Part 5A. This regime says to Trinidad and Tobago, company, limited, except for public companies, and I'll come to why we've accepted them in a moment. All companies, go and knock on the door of all your shareholders. send out a notice asking for beneficial owners to present themselves. Make sure you've done it diligently, such as to exculpate yourself by way of evidence that you've asked for this information. After you get the information, effectively, it says, go to the company's registry and file a declaration as to who your beneficial owners are. If you don't file, not only is there a penalty for not filing, but subclause 8 comes to say, because you did not file, and unless you file, you will be denied acting in the usual fashion, which is where, in the example I told you, equity prevails over law. In the usual fashion, the beneficial owner would have his way. And this now puts a bar, more than an estoppel, it's a legal bar, that says you cannot seek to take advantage of your position. And let me tell you why, ladies and gentlemen. In the allegations of corruption which grip this country, where people have not bothered to put themselves openly onto companies' registries, as you ought to, and I see Senator Ramleen smiling as I expect positions to come later in the debate. But as we look at the position where the allegation is that corrupt people, not wanting to be on the record, known for the whole world to look at, corrupt people use proxies. And the proxies that they use are men of straw or relatives. Corrupt entities go out and buy properties. Corrupt entities have them registered in other people's names, usually in a corporate structure, as we saw in umpteen examples. And then what happens is many years later, people roll up and say, I'm the beneficial owner. They may go so far as to say, look, I had a trust registered. I'm unwinding the trust. I paid my stamp duty of $25 for that registration. I have no penalty. Put me on as the owner or put the person on whom I direct. Now, if you ask my daughter, if you ask the average teenager in Trinidad and Tobago who Johnny O'Halloran is, as an example of allegations of corruption, etc., they don't have a clue who Johnny O'Halloran is. But a descendant of Johnny O'Halloran can roll up at the registry and say, oi, this property was registered in John Brown's name, but I'm the beneficial owner of that share of that company, which owns that company. I was too afraid to be known in the public domain, so I hid. And that beneficial ownership allows all of that corruption to pass, because the memory is fickle. The memory is not complete. And in Generation Z or the millennials, they have no clue. That's the ages 15 to 35. They have no clue who most people are. And therefore, putting this bar, this legal bar, in respect of which there is redress in the courts, putting this legal bar is to stop corruption in its tracks. And I am quite surprised that nobody in the media has covered this. We had this debate in the House of Representatives. Not an ounce of coverage came on a measure of such force as this. Because the law ought to be, if you are certain of what you're doing, put your name on the record for open transparency. Let people know who you are. Let them check your assets. Public registers are for that purpose. And honorable senators, lying before us now is a golden opportunity for Trinidad and Tobago to take a giant step as you now contemplate why we did all of that law prior to this one. Criminal justice reform, indictable abolition, making sure that money laundering was triable either way, creating divisions of court, having rules of court, putting more judges, moving roadblocks, start to connect the pictures, the work that is going on in the company's registry, the digitization, the harmonization of information from birth certificate to death certificate to change of name with Board of Inland Revenue. You are beginning to understand the approach that this government has taken and that this country subscribes to, and that is transparency. Take your name forthright on the record, because that's really where it ought to be. There's no odium to be suffered there. Now, one always has the opportunity under the mechanisms of the law of trusts and secret trusts to still take advantage of that. But I will tell you, the next piece of law that I intend to introduce very shortly here will treat with the registration of trusts, such that a trust other than by way of operation of law ought to be registered in a country so that you cannot hide the beneficial owner. And who in this country uses secret trusts? How many people in this country will actually use a secret trust? Will only be the extremely wealthy people in this country, or people well advised, but they have no fear because those secret trusts can be private registered. For the record, this is a public registry. A public registry. This is, in my view, most respectfully, dynamic law. Simple, potent, powerful. So, if I connect the dots, there's a legitimate aim. The measures that we bring to this legislation are rationally connected to that legitimate aim. The data shows what the legitimate aim is. We are not going any further than the measures require. We have now satisfied the umpteen cases that treat with proportionality, and they're well known to all of us. This is a requirement not only of our external assessors, this is the government's agenda. Step up, be transparent in your company's registry. Your company's registry is a public place. It's there for the whole world to look at. For $20 TT, you can inspect the entire record of a company. Full stop. Very shortly, within a month's time, fingers crossed, public service willing, we will have full online access and full e-payment at the registry for all services. And that'll be a first in this country, followed by Ministry of Works and Transport, Licensing Division, Intellectual Property, etc. We're transforming this country. It takes a while to get there. It's why I have always said in my advocacy to you, just start.
Attorney General, you have 5 more minutes.
Much obliged, ma'am. Just start. If we start on the road, we can fix our way as we are getting there. This model is ultimately closest to the Indian model, that is the law of India, and it is quite successful and robust in that jurisdiction. It's certainly something that is being tweaked as many jurisdictions progress in their positions. I do hope that I'll be able to answer. Senator Ramdeen asked a very important question about the enforceability effectively, because what happens if people don't bring in their warrants, etc., or how is it to be managed? Well, that's why we've put in the provisions that say that the company will effectively have to go and cancel the warrants. It's to be noted, in our look at this law, we didn't come across any actual issued bearer share capacity in companies that we've had, including external companies, but that's not to say that they may not be out there. That's why we are on a very aggressive drive to ensure compliance at the company's registry. I look forward to the contributions of honorable senators. I pray to be able to address the arguments that you put forward and any questions that you may have, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Companies Act be now read a second time. Senator Mark.
Thank you very much, Madam President. Madam President, I rise to make my contribution to this bill, an act to amend the Companies Act 2018, and to indicate from the very outset that when we examine the provisions or the clauses in the bill before us, we see a certain degree of deficiency. We discern a certain degree of weakness in the legislation. And quite frankly, we do not know from what we are debating here today, if it does become law, the efficacy of its final delivery would really benefit in a very serious and effective way the people of Trinidad and Tobago. I want to indicate that we understand the legislation, as the Attorney General has said, is aimed at ending ownership secrecy. It's about transparent company ownership versus secret company ownership. By disclosing, as we are advised, the identity of the real owners, the real beneficial owners of entities operating and conducting business in Trinidad and Tobago. And the Attorney General did bring to our attention that there are a lot of people in this country who use proxies in order to hide their wealth. And that the measure that we are debating today will bring about some degree of transparency, accountability, openness, and by extension, good governance. But this bill that we are dealing with has been out there, I would say, for almost 3 years now. But it has now arrived here. When I looked at the contribution in 2016 of the Attorney General on the 10th of October 2016, the Companies Amendment Bill was supposed to be tabled and the whole issue of beneficial ownership was supposed to arrive here 3 months after. So in December of 2016, it was supposed to be here. We are 3 years later, and we are now debating this bill. Madam President, there are several issues that we would like to address. The European Union and the Honorable Attorney General did not share with us this development. The European Union has blacklisted Trinidad and Tobago. And they have blacklisted us because of our inability to pass legislation to deal with the exchange of beneficial ownership information. Because we have failed to deal with customer-enhanced due diligence, and because we have failed to deal with this whole question about the traceability of funds. And the Attorney General has brought this piece of law, hoping to address the European Union's concerns, and of course, the concerns, as was indicated, of FATF. But, Madam President, we are dealing with what is called bearer shares in the legislation, and bearer shares certificate and bearer's warrant, which is almost one and the same at the end of the day. And we are told that when the Attorney General did some research in his closing remarks, there was no evidence in Trinidad and Tobago that this particular medium was being used in any serious way in this country. But it is in the legislation. But the key area that we have to pay attention to is the area of beneficial ownership, Madam President, which constitutes, as you know, a completely new section of this legislation. That is the Companies Act. So that is literally clause, in fact, it's part 5A of the legislation. Madam President, what I would like to ask very early is the definition that we have been given in the legislation, whether the Attorney General would have taken into account the concept of beneficial ownership as was proposed by the Trinidad and Tobago Extractive Industries Transparency Initiative. There's a report, Madam President, that seeks to give a definition of a beneficial owner. And I was wondering, Madam President, whether the Attorney General and the government paid any attention to this particular definition, which is extremely useful. And this definition on page 15 of a report by this TTEITI states that, and I quote, a beneficial owner is defined as the natural person who is directly or indirectly the owner of a company or controls at least 10% of the shares or total votes, exclude persons acting as a nominee, intermediary, custodian, or agent on behalf of another person. And it goes on, Madam President, to say, politically exposed persons who otherwise benefit economically from the company are also considered to be beneficial owners. So here it is. Transparency International, through the EITI, and we are an implementing country, is saying that you not only have to deal with the real persons, natural persons, but you also have to look, Madam President, as at nominee, intermediaries, custodian or agent who may be acting on behalf of such persons. And it went on also, as I said, to deal with politically exposed persons. We know under the FIU, Madam President, that is a concept that is clearly stated in that piece of legislation. So I bring this to the attention of this House so that, for instance, we can determine as a Parliament whether, Madam President, we would like to look at the definition that has been advanced in the legislation for beneficial ownership and beneficial owner. to include not only beneficial ownership, but also politically exposed persons, and have those persons captured as well in the legislation. Madam President, I would also like to have some clarification very early. I have seen, and maybe the Attorney General, when he's winding up, can address this matter. On page 33 of this particular report, I mentioned it's a report on beneficial ownership produced by the Trinidad and Tobago Transparency Institute. No, TTEITI. So Trinidad and Tobago Extractive Initiative Transparency Initiative, Industries Extractive Initiative. And this report, which was done by a lady called Tira Green, stated on page 33 that, and I quote, the company's registry electronic database contains 700,000 companies and 110,000 businesses. But we are told by the Attorney General that we only have 104,000, Madam President, businesses or companies in the company's registry. But this report, which was dated March 2018, talked about on the electronic database some 700,000 companies and over 110,000 businesses. So I don't know, Madam President, if this information that is here is misleading, because we were just told by the Attorney General that there are only 104,000 businesses in the country. So I would like him, when he's winding up, to address that particular matter. And, Madam President, we know that in Trinidad and Tobago, there are a lot of activities that are taking place that, even though they may appear to be legal and lawful, they leave a lot to be desired. And I want to go immediately to the decision of the government in Section 9 of the legislation, and I'm referring to Section 337E, which states Sections 337A to 337D shall not apply to companies publicly traded on the stock exchange. So we are being told that the concept of beneficial ownership and all that it implies and entails will only be relevant to persons who have companies, but those companies are not listed or they are not traded on the stock exchange. They will have to be governed by the section of the legislation that we are dealing with at the moment. Once you are listed on the stock exchange, Madam President, you would not be covered by the legislation that we are currently debating. But, Madam President, the Honorable Attorney General made it very clear And I would argue that there is something called the Securities Law or Act, and there is a body called the Securities and Exchange Commission that is supposed to be dealing with those companies that are publicly traded and are publicly listed. But, Madam President, would you believe that some of those companies that are publicly listed are some of the biggest, greatest violators of the very law that we are seeking to apply to small, medium-sized businesses that are not listed on the country's stock exchange. So, Madam President, we were told about how people hide their wealth, and we need to follow the money. But in doing that, Madam President, we have evidence in Trinidad and Tobago where either the Securities and Exchange Commission, and I cast no aspersions on the board of commissioners of that body. It could be that the staff, they don't have adequate resources, Madam President, to properly monitor those listed companies that have been excluded from the legislation. But when you look, Madam President, and you examine what is taking place in Trinidad and Tobago, you realize that those very listed companies are not providing the kind of information that they are supposed to declare under the Securities Act of Trinidad and Tobago. And the question that has to be asked, Madam President, what is the Securities and Exchange Commission doing about it? Is it because they are a client of some of these very listed companies, these publicly listed companies, Madam President? Is it because of that? We understand that the Securities and Exchange Commission is a client of a company called RGM. And I say no more about that. RGM is Royal Bank, FAR. G is for Guardian Holdings. And M is for Mutual Funds, which is now Sachiko. So I just raised the question as to, Madam President, Mr. Vice President, I just raised the question here as it relates to who is looking after the welfare and the interests of the citizenry of Trinidad and Tobago. And I don't understand when the Attorney General says to us, Mr. Vice President, that in his work in preparation of this Companies Act Amendment Bill, he has looked at Jamaica and Cayman Island and a number of other countries. But Mr. Vice President, if he looked at the Jamaican legislation, which I have a copy of, they dealt with the trust under the amendment to the Companies Act. Why is our Attorney General in 2019, with 1.5 years to go before he demits office, and they are removed completely from this place, why is the Attorney General not bringing into this legislation an amendment to deal with trust? Why? Because that is a vehicle that has been used by persons in Trinidad and Tobago to not only hide their wealth, but to engage in corruption and all kinds of things that my colleague referred to. That is the Honorable Attorney General. So I do not buy the argument advanced by the Attorney General that he will have to bring legislation. And you know what? He did not even give you a time frame. But I have the Jamaican legislation, and I'm going to propose an amendment to this legislation, Mr. Vice President. Mr. Vice President, you have certain strategies being used by these publicly trading companies that we are excluding from the legislation in order to hide their wealth, in order not for the country to know what is taking place. So you have this nominee shareholder, you have a nominee director, you have a nominee corporate secretary, Mr. Vice President. And you know what, Mr. Vice President? Today, if you go, Mr. Vice President, to a company called Republic Bank, which is majority owned by the people of Trinidad and Tobago, thanks to the collapse of what took place in 2009. And it hurts my heart, but that's what happened. CL Financial collapsed. The government, they came for bailout. The government is now in control of CL Financial. And they owned Republic Bank at that time. So the government has over 50.5%. So they own close to 60% of the shares of Republic Bank, or close to that. So they're in charge of Republic Bank. Mr. Vice President, this is a publicly traded company where you're supposed to have, as the AG said, transparency and accountability and good governance. When I looked at the report of Republic Bank, the last one that was published, Mr. Vice President, what you see something, Mr. Vice President, called Trin Trust Limited. Trin Trust. Who is Trin Trust? But, Mr. Vice President, this is a public company. And they are under the supervision of the Securities and Exchange Commission. And they are governed by what is called exposure to beneficial ownership. All those things are supposed to be in the law that is governing the Securities and Exchange Commission. But you have companies in Trinidad and Tobago that are publicly traded. And, Mr. Vice President, when you look at the top 10 shareholders in that company, you see a company called Trini Trust Limited. How many shares? 14,936,298 shares, equivalent to 9.2% ownership of the entire company called Republic Bank. You know the value of that, Mr. Vice President? When I last checked, one share of Republic Bank is $120. You know the value of that? $1.4 billion. Mr. Vice President, you cannot know who is Trin Trust. You're supposed to know, and the country supposed to know who is Trin Trust. But, Mr. Vice President, that is why I asked the question whether we should have included in the legislation in 337E that this section 337A to 337D shall not apply to companies publicly traded on the stock exchange. So what we have here, what we are debating here today, would not apply to publicly traded companies, only private companies that are not listed on the stock exchange. And, Mr. Vice President, this requires an investigation. What is the stock exchange doing? What is the Security, and Exchange Commission doing, Mr. Vice President? So you see something called Trini Trust Limited, with shares amounting to $1.4 billion. And when you go now and you trace now, you get into the registry as to who this thing is. It's only Republic Bank directors. Republic Bank directors are in charge of Trini Trust. ESOP is included too. That's another aspect of it. I ain't talking about ESOP, Mr. Chairman, Mr. Vice President. ESOP is another vehicle that is being used by them in order to hide wealth. So this debate that we are having here is not going to do anything to deal with the control of the elite of this country. This is almost like Mickey Mouse legislation that we are dealing with here. And the Attorney General is not serious. He's not serious. If the Attorney General is serious, he would bring serious legislation. So, Mr. Vice President, there's another one that you might want to know, and I myself would like to know. First Citizens Asset Management. What is that? Who is that? Who is behind that? We don't know. But this is a publicly traded company, Mr. Vice President. That is why I asked that we should delete that clause, excluding these publicly traded companies. Because right now, Mr. Vice President, they are not being monitored properly by the Securities and Exchange Commission, Mr. Vice President. And Mr. Vice President, that is only one aspect of this situation that we have to deal with in Trinidad and Tobago. When you go to another publicly traded company, Mr. Vice President, I think it's, you have something called Massey. That's another company, Massey. I hear that they're taking over the whole southeastern bloc in terms of gas. BPTT and Massey taking over energy in TNT. But here what's going on here, Mr. Vice President, when you go to this particular report from Massey, you see something called RBC, RBTT, Nominee Services Limited. Mr. Vice President, there's something called the National Insurance Board. You know who's the National Insurance Board. You can identify with the National Insurance Board. We have money with them. We pay, so we know that they're investing on our behalf. Mr. Vice President, this is a publicly traded company. You see something called RBC, RBTT, Nominee Services Limited. How many shares they have here, Mr. Vice President? 10,245,639 shares. Who are these people? Who are these people? Let us lift the corporate veil so we can see who these people are. We don't know, Mr. Vice President. Mr. Vice President, Trini Trust, you know them existing, this company existing since independence? Having a good time. And Mr. Vice President, look, they appear in this thing too. So they're also in Massey. So there's another one called RBC, RBTT Trust Limited. We don't know who these people are. So, Mr. Vice President, the point I'm simply making, we are dealing with legislation in our parliament today, and as lawmakers, we appear to be puppets of a larger agenda. So we are passing legislation that will not be able to bite. in any serious way, Mr. Vice President. This is weak legislation. It will not accomplish the objectives that the government is seeking to deal with, Mr. Vice President. And therefore, I ask the Attorney General to deal with the whole question of beneficial ownership in a broader sense. And that is why I include politically exposed persons. I am very clear, no? I'm a politician. I'm a public figure. If I do the crime, I am going to do the times. I have nothing to hide. And once you're in public service, you should be exposed to public scrutiny. And if you're talking about beneficial ownership, you should include politically exposed persons in that concept as well. Don't leave them out. Where? Where? I didn't see it in the definition.
Everybody is wider than Pepsi.
Mr. Vice President, I give you see the Honorable Attorney General, I know you are disturbed, you know.
Mr. Mark, no.
All right, but let me just address you.
No, we don't. We're not going to go down that route.
I'm not going
Good.
to anticipate anyone. You know I'm a very decent fellow.
I know you're a very decent fellow, but telling this Attorney General that he's disturbed is not allowed. No, that's the road I'm talking about. Continue.
So what I'm saying, Mr. Vice President, is that when we are dealing with the big sharks in Trinidad and Tobago, people are demanding fair treatment in this country. They want people to pay their fair share. Mr. Vice President, there are corporate service providers professionally operating in this country who are manufacturing shell companies. They manufacture shell companies by the hundreds in this country. And those shell companies are being purchased at a price by their clients whenever they need it. Is that allowable in a society that is seeking to promote accountability, transparency, and good governance? Is that allowable? Are they not creating vehicles? Mr. Vice President, I would like to tell you that when I look, I don't know if you read like I did, but I read. It was on page 11 in the Sunday Express, March 10th. The headline is SEC to settle with Lockjack and Ahmad. And when I read this, I couldn't believe what I'm reading. What is the SEC doing? Mr. Vice President, you have a takeover bid that is being made by a company called NCB Holdings, Trinidad and Tobago Limited. Yeah, Holdings Limited, Mr. Vice President. And you know what's going on, Mr. Vice President? They want to take over 62% of this company called Guardian Holdings. But I saw where the value of the shares, 69 million shares, is valued at 207 million. But the person who is taking over from Guardian Life, NCB Holding, is being given a loan by Guardian Life, who is being taken over, to buy over Guardian Life. I don't understand what is going on. So, what is the Securities and Exchange Commission doing? Is this allowable on this stock exchange, Mr. Vice President? I am taking over your company. I am lending you money, Mr. Vice President, so that you could take over my company? Is that allowable? Is that allowable? I don't know. These are issues that are bothering me. And we want to get some clarification as we go along. Mr. Vice President, there are provisions in the Jamaican legislation that I would like the Attorney General to pay attention to. The Attorney General, there is a section, Mr. Vice President, that deals with notice of trust. This came in the amendment of the Act, called an Act to amend the Companies Act of Jamaica in 2017. And they included trust in this. So why are we leaving out trust, Mr. Vice President, in the legislation that is before us? So we would like to call on the government to deal with the following issues. One, the Attorney General said it takes $20 to go and search for a company. Mr. Vice President, to register, to search for a company, you have to walk with $500. It's not $20. $20 is per search. But to become registered, to access, you pay $500. Why is the government using the weapon of money to disallow people from searching the registry? We're trying to determine how much Valsain Resort Limited got for Kedona. Don't matter how we try, we can't get it. We can't get it, Mr. Attorney General. We're hearing figures of 33 million, 40 million, 50 million. We don't know. I hope the minister will be kind enough, seeing that he's the real owner, to tell us this evening how much money he got for the Kedona, because I can't get the information. Try as I may. Try as I may. I want to get to the... And Mr. Vice President, I know that my time is coming to a close. Sometimes I wonder whether we should have a registry for the government. Because we have legal persons in the cabinet. But the natural persons who control the legal persons, we need them to be identified. We need to know who are the real owners of the government of Trinidad and Tobago. It is not the people. So sometimes, Mr. Vice President, I feel that we should have a beneficial ownership register for the government of Trinidad and Tobago. So we will know if SPNA is the real owner of Petrotrade Legacy. I feel sorry for the Minister of Energy, to be honest with you. Under pressure. So, Mr. Vice President, when we come to this reality that we are dealing with in Trinidad and Tobago, we call on the Attorney General to make EITI is calling for a public central registry in Trinidad and Tobago that is accessible to the public. We support that. I support what is happening in England today, Mr. Vice President, in the UK. There is something called persons with substantial control. There's a registry called beneficial ownership. You can say any part of England, Mr. Vice President, and punch in your password. And at no cost to you, Mr. Vice President, you can get any information on any director, any company, anybody in the United Kingdom. We want the public to have free access to the beneficial ownership registry in Trinidad and Tobago, Mr. Vice President. I thank you very much, Mr. Vice President.
Senator Vieira.
Mr. Vice President, the cooperation must rank as one of mankind's greatest inventions. And given the ambit of Section 3 of the Companies Act, it is indispensable for trade and business, as no association, society, body, or group consisting of more than 10 persons may be formed for the purpose of carrying on any trade or business for gain unless it is incorporated under the Companies Act. It was a partnership or was formed under some other written law, such as an act of incorporation. Section 21 makes clear that a company has the capacity and all the rights, powers and privileges of any individual, including the power to own property, capacity to carry on business, capacity to enter contracts, capacity to sue and to be sued. Most importantly, companies shield shareholders and owners from liability so that their personal assets are protected and generally not in jeopardy to satisfy corporate obligations and creditors. Companies also have great flexibility of ownership. Incorporators and shareholders can be individuals, 18 years of age and over, who are not mentally ill or undischarged bankrupts. Shareholders can be foreign or domestic. They can be other companies. And shares can be held in trust or via some other legal tool. So almost anyone or anything can be a shareholder. And this allows a business to seek partners in capital from a variety of sources. Companies offer credibility. As most of us will have discovered, it is easier for a company to raise financing from banks and other financial institutions, as investors and businesses will sooner deal with a company than with an individual. And companies, like trademarks, have the potential for perpetual existence. In other jurisdictions, some companies have actually been around for centuries. So all things being equal, most companies will outlive their shareholders. And companies offer great flexibility as well when transferring ownership. Shares can be sold in whole or in part. New owners can be brought in, and ownership can pass down within a family. Companies can be and are often used as an asset protection vehicle. So it's no exaggeration to say that companies may be the most influential institutional model of our time. And the Companies Act and the Companies Registry are its lifeblood. But companies can also be vehicles for dark money and wrongdoing. Because companies can own property, bid for contracts, and operate businesses just like individuals, they can engage in bribery and corruption. Companies can facilitate money laundering and terrorist financing where the persons ultimately behind the operations are not readily identifiable. And because of the powers and privileges afforded to companies, and because of the potential available to them for both good and evil, the principles of transparency, accountability, and good governance are paramount. Now, as the Attorney General has indicated, we have a huge underground economy in this country. You're talking about 350 companies participating in over $15 billion in suspected criminal activities. Members of the public, persons engaging in legitimate trade and business, financial institutions, and law enforcement should not have to deal with companies on a cat-and-bag basis. Everyone should be able to know at any point in time who are the incorporators and shareholders, who are the directors and officers, where to find the company, where's its registered address, whether the company is a private one or public one, what are the classes and numbers of shares in each class that the company is authorized to issue, restrictions, if any, on the transfer or ownership of shares. And it is important that the company's registry be updated as and when changes occur. So compliance with the incorporation process, annual returns, and disclosure requirements are critical. And where companies are tardy, negligent, or wanting in meeting these important obligations, it is only right and proper for effective and appropriate penalties to be imposed. People need to know who they are dealing with. The veil of incorporation merely means that a company is to be distinguished as a separate person from its members. But it should not be used as a cloak by criminal organizations, terrorists, and corrupt individuals for hiding the proceeds of crime, corruption, or other forms of wrongdoing. And that, as I understand it, is the primary purpose of the amendments being brought under this legislation. When a company acquires land, it bids for public contracts, or it engages in business, everyone should know who exactly they are dealing with. Who is behind the operation? Who are the investors and the owners of the company? Who has significant control? And who ultimately benefits? And that is what beneficial ownership is about, and why Clause 9 is so important. By requiring the ultimate beneficiaries and persons of significant control to reveal themselves, transparency is increased, and the opportunities for money laundering, terrorist financing, and wrongdoing are concomitantly decreased. The prohibition against bearer shares, bearer share certificates, and share warrants is also part of this thread. Clause 4:14 defines bearer shares as a negotiable instrument that accords ownership in a legal person to the person who possesses the bearer share certificate. Well, the objections against bearer shares and bearer share warrants relate to the lack of transparency and control, as ownership of these shares is not recorded. And because bearer shares allow for anonymity of ownership and transfer, they're vulnerable to misuse. Because these shares are not registered to any authority, transferring their ownership involves mere delivery of the physical document, that is, by the individual who is entitled to the company's underlying assets, by virtue of physical possession of the bearer share certificates. Not surprisingly, bearer shares have or are being eliminated in most jurisdictions. Indeed, many countries have outlawed the issuance of new bearer shares, and where bearer shares are already issued, they are strictly regulated. Now, our Companies Act at Section 33(2) prohibits the issue of bearer shares and bearer share certificates. And that has been the law since 1995. But there are disparities, as we've heard from the Honorable Attorney General, which this amending act hopes to clarify and resolve. So, for example, where bearer shares were issued prior to the Companies Act, this is in relation to former Act companies, the company will now have to prepare and maintain an appropriate register. The SEC, that Senator Mark was talking about, will be empowered to get information from companies about their bearer shares and bearer share warrants. External companies will now be prohibited from issuing bearer shares and bearer share warrants, and where such were issued previously, they must be duly registered. These provisions are all part and parcel of being able to identify and to register the real owners of companies. So, given the potential for mischief and the risks involved, I fully support administrative restrictions, criminal sanctions, and fines for non-compliance. But I want to say, though these measures may bring us in line with international best practice, FATF, and emerging global standards, that is not the only reason why I support them. I support these new requirements, having seen firsthand the type of injustice that can be perpetrated against the innocent, be they employees, those legitimately involved in trade and business, those going through the throes of a divorce, and law enforcement, the sort of injustice that can take place where entities are allowed to give misleading or false information or are unwilling to identify those who exercise ultimate control or significant influence. Now, it has been said that the enemy of excellence is perfection. And I want to say that it's important to bear this in mind because no legislation is perfect. Much still needs to be done to expand the scope of corporate criminal liability and to make it easier, for example, for prosecutors to establish corporate criminal liability for offenses where persons constituting the directing minds of the company are found to have the necessary acts with the necessary intention and mental state. So much still needs to be done in terms of prosecuting corporates and ramping up our legislation, but it's a work in progress. This is an important step. This legislation is relatively straightforward. Government exists to act in ways that improve the lives of its citizens or their security. These transparency measures are, in my view, proportionate, timely, and necessary for those objectives. I thank you.
Senator Simonette.
Mr. Vice President, I thank you for the opportunity to make a contribution to this very important amendment to our Companies Act, entitled an Act to Amend the Companies Act. Mr. Vice President, the backdrop of my contribution is going to attempt to simplify the focus and intent of the amendment bill being proposed by the government. As my honorable friend Senator Vieira indicated, the existence of the company came into being to permit for economic activity of a legitimate nature and for the expansion of trade carried on by persons engaged in business for the benefit, obviously, of those participating in the company, both as to ownership and as well as those employed by the company. And so the birth of the modern limited liability company way back in the United Kingdom came about to facilitate legitimate activity, legitimate business, and legitimate trade. And the incorporation of this vehicle or this entity called a company also permitted the assumption of a certain degree of risk by those purporting to engage in that legitimate trade and/or business. As is known by those of us who practice in the area of company law and by many legitimate business persons, the company exists as a separate entity from those who own it and those who have incorporated it, and permits for a limitation of liability to those who own the company, as the company's existence is treated to be separate from that of its incorporators. And so modern company law, starting in England and Wales, transported to Canada and elsewhere, including, of course, Trinidad and Tobago, recognizes what is called the veil of incorporation. And the veil of incorporation may also be looked at as the mask of incorporation, as some learned authors in this area of the law have chosen to describe it. And what that means is that the company exists as its own entity in its own name, and one is entitled to treat with it as such without having to look deeper inside to determine who are the persons, the actual, what are called the alter egos, or the actual human beings behind the company. And the veil of incorporation also emerged to facilitate a certain degree of privacy, dare I say, in modern era, secrecy in terms of the proliferation of what has come to be known in the wider world as international business companies. And whilst Trinidad and Tobago does not have such a regime of companies, our sister CARICOM nation of Barbados provides for such companies. And so there is a degree of secrecy that applies to companies via the traditional regime of incorporation. Company law has long recognized that that veil of incorporation could be pierced where there is the practice of fraud, where there is the practice of tax evasion, and by tax evasion, one is addressing the issue of the non-payment of legitimate and due taxes to the government. So that when we look at what is being pursued now in the modern era of transparency and disclosure of those who stand behind companies, it doesn't come entirely as a shot, Madam President, in the dark, or in the realm of some intrusion to any constitutional right or privilege. Mature company law has long recognized that the veil of incorporation would be pierced where companies are being used for improper purposes and for engaging in fraudulent activity. But what has transpired, Madam President, in the regime of rules and regulations being advanced in the modern era of confronting money laundering and the financing of crime and terrorist activity is the creation of rules and regulations that permit for the more readily available access to credible information of what has been called the beneficial ownership of companies. And in simple terms, what that beneficial ownership phrase depicts is this: we ought not to await something to have gone wrong to pierce the corporate veil to determine who ought to be made liable for unlawful and illegal and illicit activity. There ought to be a system which enables those with the duty to enforce the law to very speedily identify who the true and actual wrongdoers are. Because what the successive life existence of companies has demonstrated over the last, since 1948, with the coming into being of the Consolidated Companies Act in England, is that lawyers, accountants, and other financial advisors have been very competent at creating layers of ownership that mask, at the end of the day, the true ownership of companies. And so that skill, ordinarily sometimes used in the legitimate purpose of trying to achieve anonymity and secrecy, has, of course, in the proliferation of sophisticated criminal activity, been also now used to hide the identity of wrongdoers. And wrongdoers not just in terms of heinous crime, resulting in physical harm and the abuse of human beings, including children, and by that I speak of human trafficking, but also those involved in the hiding of illicit gotten gains from corruption, from illicit drug trafficking, and also as well those who seek to evade paying their just contribution to the public coffers by way of taxes. And so the emergence of the international organizations that have now corralled virtually all modern states to agree to a system of transparency and disclosure aimed at eliminating those who wish to use the veil of incorporation and other legal instruments to hide and to obscure their existence and their participation in wrongdoing is now of general application, as the Honorable Attorney General has shared with us, to countries such as Trinidad and Tobago. So that the aim of this amendment bill is to ensure that there is credible registration, recording, and dare I say, consequences to flow in terms of penalties and criminal liability for the failure to properly register the beneficial ownership of shares in companies. Now, Madam President, again to attempt simplifying the mischief that the amendment bill seeks to address, one must appreciate the structure of companies and how they come to make decisions, open bank accounts, transfer money, own property, and so on. A company is incorporated by persons who initially promote the company, that is, they seek to bring it into being by the act of incorporation, which is, as lawyers know, a legal mechanism of registering, paying certain fees, obtaining prior to that approval of a name, and bringing the company into being. But the owners of the company are the shareholders of the company. The company also operates via its directors, who are said to be the controlling minds of the company. But as those of us who are familiar with the company law, the true controlling and largest controlling and dominant controlling body is the body of shareholders when they meet in general meeting. And so those who control the shares of the company, the shareholders, are in fact the controlling persons or entities of any limited liability company. However, the law prior to this amendment bill provides for shares to be owned by nominees of the true owners, and those true owners are the persons whom the Honorable Attorney General has been referring to as the beneficial owners, and for shares to be owned by also other legal personalities such as companies and trusts. Senator Mark made heavy weather of trust companies not being addressed by this act and by public companies not being addressed by this, amendment bill. Dare I say, Madam President, that the control of public companies is well documented to be under the purview of the Securities and Exchange Commission. And I would say no more on that. I know that the Honorable Attorney General will deal with that in perhaps more detail than I would in the time allowed. So that the beneficial owner of the share is the person who ultimately owns the share and ultimately controls the shareholder who may own the share or be registered as the owner of the share in the name of the beneficial, on behalf of the beneficial owner. What the legislation seeks to do, the amendment, is to unmask or lift the veil of all of that prior permitted secrecy, which, of course, as we are aware, has been used for wrongdoing in the area of money laundering and illicit activities, including the financing of terrorism. So that without having to prove or to pierce the veil under the old regime via having to take action and application to the court, what this compliance with the directives of the Financial Action Task Force and the Caribbean Financial Action Task Force is seeking to do in the several sections of the Act is to create an obligation on those who currently own private companies. And I wish to make an intervention here, Madam President, on the apparent dismissal as being ineffective of the legislation, because the real mischief exists in public companies. This was the point being made by my learned friend, Senator Mark. The statistics, however, show an entirely different picture, or rather, a picture that fully demonstrates the enormity of the corruption and of the existing wrongdoing within Trinidad and Tobago. And the statistics, Madam President, are as follows. For the year 2016-2017, 117 companies were involved in 14 billion suspicious transaction reports and suspicious transaction reports and suspicious activity reports identified by the Financial Intelligence Unit. that is $14.5 billion for 2016-2017. Madam President, that is no small sum of money. And it is not, they're not transactions allocated to what are known as public liability companies or companies registered on the stock exchange. So let us be very serious about what we are about here and about what the realities are in relation to the existence of a serious problem in our economy and in our society. And dare I say, the requirement to tackle this problem has been with this country well before the current government embarked in September 2015. And as a nation, we ought to be extremely proud of and recognize the outstanding work of the Attorney General and his office and those in the Ministry of Legal Affairs. Let us make no joke about it, Madam President. These matters were not tackled by the previous government. They were not tackled by the previous government. Indeed, as my learned friend, the Attorney General, has shared with us, they put us on a fast track to evaluation without having done the underlying work. So that when we come, Madam President, to consider the regime under which the disclosures are being required to be made, we see that the registration requirements in this amendment bill are proportionate, and indeed one can liken them to the period where we converted from the old Companies Act to this current Companies Act, the 1995 Act, and provided for a period of the continuance and a regime for the continuance of old Act companies to the new Companies Act, then New Companies Act in 1995. So that everyone engaged in company existence and company activity in the private companies sector will be permitted a reasonable period of 30 days within which to bring themselves into compliance with the disclosure and the filing of disclosure information on true beneficial ownership. Of course, the bill would be impotent, not as my learned friend Senator Mark indicated, but impotent if it did not provide for a sanction for failure to comply. And so if you fail to comply in certain instances, your name can be struck off. But again, if you can show reasonable cause why you had not complied, and this is the proportionality of the bill, you can make an application to the court pursuant to the current provisions of the Act to be reinstated. Madam President, the world movement towards transparency and disclosure. Madam President, could I ask how much time I have left, please?
4:26.
The world movement towards, much obliged, Madam President, the world movement towards further transparency and disclosure also requires that we comply with the issue which may not be known to the ordinary citizen of bearer shares and bearer share warrants. And in this area, it is important to note that whilst, as Senator Vieira correctly observed, our current legislation does not provide and prohibits the issue of bearer shares, it does not mean that bearer shares may not be in existence to pre-1995 Chapter 8101 companies incorporated under what is called the old company law. So what then is a bearer share and what is a bearer share warrant? A bearer share is a certificate that in the possession of the person, the bearer, entitles that person who is in physical possession to the underlying ownership of the share and what the share represents in the relevant company. And why is this issue of the bearer share of such importance? The issue is of such importance because a bearer share is not required to be recorded or registered in any register. And additionally, its transfer or its exchange from one person to another can be done with the utmost anonymity and accordingly used very effectively in all manner of wrongdoing. Similarly, Madam President, a bearer share warrant is a document which is certified by the company, the relevant company that issues the warrant, that the bearer is entitled to the amount of money recorded in the bearer share warrant in respect of the ownership in the capital of the underlying company. Again, a document that is easily transferable without any requirement prior to now to register same. So that the amendment proposed is that those who hold bearer shares and those companies who are aware that they have issued bearer shares or that they have bearer share warrants that are valid are required to register the owners, the true owners of these shares. And if those shares are not registered by the true owners, then the company has an obligation to so do. And in default of so doing, there are penalties that flow. And dare I say, Madam President, the proportionality of the legislation, of the proposed legislation, permits a reasonable time period within which to comply with these requirements. In addition, Madam President, a feature of the bill is the requirement for certain disclosures and status reports to be the subject of statutory declarations. And again, such a provision goes very firmly in answer to the potency of the legislation and the potency of how the legislation will operate to deter wrongdoing and illicit activity. As we are all aware, if you contravene the truthfulness of a situation pursuant to a statutory declaration, you are subject to criminal penalty. Madam President, the bill in its focus on the unmasking of secrecy and on the unmasking of true ownership in that regard is in keeping with the focus and commitment of this government to bring our laws into effect, to ensure that laws don't just exist either in archaic chambers, unamended, unattended to, but that they are relevant to the ordering of our society in a manner intended to uplift the society and uplift the compliance of those of us who require there to be orderliness, a respect for the law, and dare I say, a respect for contributing to our due share to the public purse for the delivery by the government of the care for what those of us who are old taxation commentators call the care of the government from the cradle to the grave. But that care requires financing, and that financing comes in the main from proper administration of our taxation regime. And so this law seeks to achieve that both in terms of our own national population, but also in terms of the interrelationship amongst the members of the community that are of the world community that are seeking to ensure that those who are hiding their ill-gotten gains or hiding their money in different jurisdictions are able to be identified for the purposes of raising, certainly in the area of taxation, of raising and imposing appropriate, adequate, and fair taxation. So, Madam President, I must disagree with my friend Senator Mark that the legislation is either impotent, inadequate, irrelevant, or insufficient. I think that the Honorable Attorney General and his dedicated staff and assistants have done an incredibly good job in the suite of legislation that has brought us to the point where we face the next evaluation with confidence that we can stand proud of having complied with our obligations, both international as well as our obligations to the people of Trinidad and Tobago with regard to making Trinidad and Tobago safer, making those who are resolved to continue pursuing illicit activity aware that these instruments, that these legal mechanisms will permit them to be identified and to be held to account. Madam President, the issue of non-profit organizations being brought into this regime is, as the Honorable Attorney General indicated, being addressed, and no doubt that regime will likewise permit for the transparency and the appropriate regulation required in the circumstances of keeping within the objective of limiting the access to using the veil of corporation or incorporation to perpetrate illicit activity. Madam President, the last thing I would like to say is that not that it requires us to follow fashion, but our amendments are no dissimilar to those of our CARICOM neighbors in Jamaica, in Barbados, and as the Honorable Attorney General has indicated, we have quite respectfully, in St. Lucia as well, we have quite respectfully learnt from the very solid work of our Indian Commonwealth neighbor. Having said that, Madam President, I beg to move that we support this amendment bill. We support this amendment bill, and with those words, I thank you.
Senator Ameen.
Thank you very much, Madam. Madam President. Madam President.
You should have done some of that.
I want to thank you for the opportunity to contribute today. As I sat and I listened, several speakers gave explanations, gave definitions, and indicated their position in terms of support or concerns that they have. I don't think that any person who sits in this parliament has any objection to transparency, to measures against corruption, against secrecy, against shady dealings. So that is an area where I don't expect us on either side to have any strong objections in terms of in principle, what this legislation, the objective of this legislation. Madam President, it is very clear that this government intends to list as achievements legislations brought to Parliament, legislations passed. And while that is, of course, the portfolio of the Attorney General to pilot legislation, I want to add it should be to pilot good legislation and to bring good law. But, Madam President, my main concern is that while the Attorney General would have brought legislation, there are a number of pieces of legislation that required a special majority and required the intervention or the cooperation of the opposition. And we have always said in the opposition that we will support good law, and that remains. We have cooperated with the government on the anti-terrorism, on the FATF, on the anti-gang legislation and others. But, Madam President, I want to implore this government that your real achievement should not just be the fact that you come in Parliament and on paper you have legislation. Your real achievement should be what have you done in enacting that legislation and enforcing that legislation. And all the pieces of legislation that you have moved, and granted that sufficient time will be required to implement these measures, can you, at the end of your term, account to the nation in terms of who have you caught? Who have you, not just by arrest, but by complete prosecution and seeing it through where justice is really brought. And that is an area I think the government is really short on. In this particular piece of legislation, Madam President, the Act to Amend the Companies Act, the challenges to start off are already issues that already exist and have to be corrected. The condition of the company's registry, for example, is one of those things that falls under the Ministry of Legal Affairs, and it should be, I'm sure it is of concern to the Attorney General and his colleagues. Madam President, even now, the computerized system within that registry, where you have divisions in Arima, in San Fernando, and the main branch in Port of Spain, are not well linked. If you do a search in Arima, you are very likely to come to Port of Spain and get different information. And I have known of people who conducted searches, applied and registered companies, and were told afterwards, listen, we have to scrap that registration because we didn't realize there's another company with a very similar name, or for some reason we cannot give you to go ahead with that name. And particularly when you have businesses that are just starting up, those things could throw them off. When people, they start to do their branding and their advertising, their artwork and marketing. But, Madam President, the point is that the registry is not well coordinated. So that is something that I think I'm sure in order to streamline things should be corrected and should be a concern of the Attorney General and his, or the Ministry of Legal Affairs and those there. The agencies who would be responsible for monitoring these, the enforcement of the measures, there are certain clauses that identify fines, for example, that identify what the punishment would be if the person commits an offense. These agencies, Madam President, the question again comes in terms of the resourcing of these agencies. And every time you bring legislation that gives a department or an agency more work, the question must come in terms of, do they have the capacity at present, or does the government intend to improve their capacity so that they can deliver effectively, to make this legislation, to make your good and excellent legislation, as the speaker before me described it as, to make it effective. Madam President, we have heard on numerous occasions issues with regards to the Financial Intelligence Unit and constraints they have in terms of their resources, in terms of, I shouldn't say their resources, their challenges. It's broader than just their resources, but their challenges. In terms of the number of successful cases they have investigated and brought to the court and successfully pursued. That all of those issues are very relevant in these instances. In terms of the National Police, the Fraud Squad, and the other relevant departments, including, it could even extend as far as the cybercrime and so on. Are they sufficiently equipped to deal with the offenses created under this legislation? Some of these offenses existed before. The fines may be changed and improved, and that's good. But the question is, does the police have the technical skills, the technical support, the equipment, the manpower to treat with this, in addition to all the other pieces of legislation that we as a parliament would have agreed to? and they are quite numerous. I don't need to repeat also, Madam President, the office of the DPP. We have had numerous debates where we talk about the court, changes in the family court and in other pieces of legislation where the DPP's office would play a critical role. And from the housing of and the accommodation of the DPP's office in a mall, to the staffing, to the number of vacant positions, to the fact that they don't have paper to photocopy sometimes. All of those things have been ventilated.
Honourable Senators, at this stage we will suspend and return at 5 p.m. The sitting is suspended until 5 p.m.